In the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good afternoon, Council. We're here today on S-1-SC-38869, State of New Mexico versus Atencio, which is consolidated with S-1-SC-38565, State versus Cairamonte. Can I have entries of appearance, please?
Morris Vaimanis for the State of Mexico.
Nina Lopez, on behalf of Zana Chiaramonte and Carlos Atencio.
Thank you. Mr. Vitamanis, it appears that you've asked for 20 minutes for your argument in chief and reserved 10 for rebuttal. Is that correct?
That's correct.
All right, you can proceed.
Good afternoon, may it please the court. I'm going to start with the Atencio case. The Court of Appeals decision in this case is not supported by authority, record, or logic. The only authority that the court cited was the Cerna case, which doesn't support the holding because that warning said that the suspect had, quote, the right to an attorney during any and all questionings, and thereby restricted the right to the time when questions were being asked. The Atencio warning did not do that. Cerna did not say that the warning had to use any specific language. The U.S. Supreme Court also has repeatedly and plainly held that no specific language is required to satisfy Miranda, and that comes from the U.S. v. Nash case in the Fourth Circuit that I've cited.
Mr. Vitamanis,
Yes.
just as an initial question, both parties seem to rely on Cerna. Do you think it is appropriate for this court to adopt the Cerna standards?
I think this Cerna is a very well-written decision. I have no problem with it.
Okay.
And
Just so that we know what framework maybe you're going to argue your case through and maybe opposing counsel as well.
yeah, obviously the case is not binding on this court, but I have no objection to the court adopting that.
Thank you.
This decision also is not supported by any fact in the record indicating that defendant did not understand the Miranda warning he was given. In the trial court, the defendant did not even claim that he misunderstood the warning. That's why the Court of Appeals relied on the fundamental error doctrine. The decision also is not supported by logic. Telling a suspect before questioning that he has a right to a lawyer necessarily means that he has that right from that moment on, before as well as during questioning. Cerna pointed out that a warning regarding the right to the presence of counsel adequately conveys that the right applies both before and during interrogation. This warning was not ambiguous and does not make the right to counsel contingent on any other event. Numerous federal and state courts that I cited in my briefs have held that such a warning is inadequate. The Court of Appeals stated that somebody in defendant's position could easily understand a warning to refer to his right to counsel if he was charged with a crime, not to a right to the presence of counsel before and during questioning. That does not make sense, and not just because the warning didn't say that. Look at when the warning is given. Police are required to warn a suspect before the start of questioning that he has the right to counsel. Now, when read in the common sense way that the U.S. Supreme Court says these warnings should be read, how could a warning about the right to counsel given before questioning be understood to refer to that right at any period of time other than questioning, the entire duration of questioning? Turning now briefly to the other case, which I understand the correct pronunciation is Shiramonte, based on what I heard on the audio recording. Warning in this case is similar, but not quite the same. It said that the defendant had the right to an attorney and have him present with you while you were being questioned. This case is somewhat like the converse of the U.S. Supreme Court's Florida v. Powell case, where the warning informed the suspect of his right to talk to a lawyer before answering any of our questions, but did not expressly state that the lawyer could be present during questioning. The Supreme Court upheld that warning. Here again, other courts, including the Ninth Circuit, have upheld the same warning, and defendant has cited no case that has found it to be inadequate. Defendant attempts to distinguish such cases that I cited because of the warning said that the suspect has the right to, quote unquote, consult with an attorney. But that's not persuasive because obviously the right to an attorney includes the right to consult with that attorney. Once defendant was advised that he had the right to an attorney, this again meant that he had the right from that moment on. The right to have the attorney present during questioning is simply an additional right and does not restrict the entitlement to counsel to the time that questioning takes place.
Could we write an opinion in this case, or in these?
I'm sorry, ma'am?
Could we write an opinion in these consolidated appeals that affirms in one instance and reverses in another and be consistent?
Well, a court could certainly do that. I don't believe that there's any real difference in the meaning of these statements. And again, in the Shiramonte, well, let me put it this way. If you don't buy my argument in Atencio, I don't think you're going to buy my argument in Shiramonte because they both, to some extent, depend on is you have the right to a lawyer. Okay.
So I can see a path, and I don't know where I'd land on this, but I can see a path that actually agrees with you on Atencio and disagrees on Shiramonte because of
that's
the,
what I was saying.
okay, I was like,
That's what I was saying.
thank you. I was like, yeah, but I don't think I could, the inverse wouldn't.
I don't think
Be
you
true.
can.
Okay.
There is a cross appeal in Atencio, and I can address that briefly, but before I do, does the court have any questions about this part of the argument?
You can proceed.
Let me just point out a couple of other things, and
Sure.
I'm going to make 2 points, and you may say this doesn't get you all the way, and I would agree with you, but I will just point them out. I've never seen any case in this area except the Atencio decision that went the way it did based on the fundamental error doctrine. Now, you could say, well, we'd have the issue anyway, and you'd be right about that. But, you know, if the defendant and his trial counsel don't even raise the issue, I think that is a factor. Another factor I'll mention, and I know it doesn't get me all the way, but, you know, if this warning is so inadequate and misleading, wouldn't you think it wouldn't take 54 years in this state before somebody raised this issue after the Miranda's decision, and 55 before the court agreed with that argument? I will also point out a few things about the U.S. Supreme Court's decisions in this area. And I recognize that they have not specifically addressed the point that is before the court today, but I'd like to make 4 points about that. Number one, in the 3 post-Miranda decisions, the Supreme Court has never held that the warning before it was inadequate. Number 2, as I said earlier, the Supreme Court has repeatedly stated, as long as the warning reasonably conveys Miranda rights, we're not going to prescribe a specific language. Number 3, the Supreme Court has had a number of opportunities to review cases that have gone in favor of the state's position with this exact Atencio warning and has declined review. Now, I know that they say don't read too much into a denial of cert, and I think that's valid if we're talking about one case, because the court might say, we want to review the issue, but that's not the right case. Mm-hmm. But when it happens repeatedly, I think you can draw a conclusion from that. Finally, if you look at the California v. Price Act decision that I cited in my reply brief, the court repeated that you don't have to have any precise formulation, and cited a case called U.S. v. Lamia, Second Circuit, 1970, which held that a warning that the defendant had the right to an attorney, the very same Atencio warning, was adequate. On the cross appeal, I presented my arguments in my brief. There was no reply brief, but I will just touch briefly on what I believe are the key points. Mm-hmm. Here, I think the Court of Appeals correctly concluded that the evidence was sufficient to sustain defendant's convictions. The charging period was established both by the testimony of the victim's parents and also by defendant in his police interview, who basically agreed with the time frame that the parents talked about, and was divided into 5-day periods. The victim testified that he went over to the defendant's house every day, and that the defendant touched his private parts under his clothes every day. That is quite similar to the testimony of the victim in this court's decision in the Lenti case. Moreover, defendant admitted that the victim stayed with him 25 to 30 times, and that he touched his penis about 25 to 30 times. So the defendant admitted to at least as many instances of criminal sexual contact as he was charged with. If there are no other questions, I will not take up the court's time any further.
Any other questions?
Yes.
So what would you say is the decision, the holding in the Atencio case?
As I understand the Atencio holding, it is that the Miranda warning has to explicitly state that the suspect has the right to an attorney both before and during the interview. If you look at paragraph 35 of the decision, the court said you don't need to use any particular language, but then a couple sentences later, kind of seemed to say the opposite. That's my understanding of the Atencio holding,
That they need to say the words before or during questioning?
before and during
Before
questioning.
and during questioning?
Yes.
Do you read it as advising them of the presence of an attorney takes care of that?
I think Serna certainly says that.
Well, I'm reading it, and I'm asking you, it's.
I don't think that's what they're saying. Because this warning basically said you have the right to the presence of an attorney, and they said that wasn't enough.
Right. So do you think, my follow-up question would be, do you think that Atencio sees a difference between presence of attorney versus right to attorney?
I may have thought that when I first read the decision. I don't really think so now because I don't think there is any difference. It would make no sense to tell somebody you have the right to an attorney, but gee, unless we tell you otherwise, you don't have the right to its presence. So I don't think the court was saying that.
Okay.
Any other questions?
Custodial interrogation in Atencio.
Yes.
The way I read the facts, it sounds kind of like he was there voluntarily and was not in custody.
That's what I argued in the Court of Appeals and I lost. So,
Do you have anything to add that you argued?
well, I don't think it's fair for me to sit here and argue it because I didn't appeal it. It was one of those calls where I don't really think they're right, but it's close enough that I thought we ought to have this appeal on the principal issue.
Okay, thank you.
Thank you.
Thank you.
May it please the court. I believe an important point to begin with is that these are two very different cases. In Mr. Chiaramonte's case, the officer read a warning that said you have the right to an attorney and to have him with you during questioning. California versus Prysock and a number of other cases, including our case, State versus Serna, have made it very clear that temporal limitations on the right to counsel are prohibited. Mr. Chiaramonte puts forth that this was a temporal limitation on the right to counsel because it only mentioned during questioning and didn't give Mr. Chiaramonte any reason to believe that the right began prior to questioning. And so Mr. Chiaramonte would ask this court to quash cert. Both the district court and the Court of Appeals agreed with him that if this was a case that involved temporal limitations, something that's clearly prohibited.
Counsel, is there really a temporal limitation in that warning? It says you have a right to an attorney and to have him present with you while you're being questioned. It sounds like here's your right to an attorney, and included in that right is your right to have him with you while you're being questioned. But the overall right described in Miranda is in that warning, isn't it?
I believe it is not, because when you say it all in one sentence like that, there's no punctuation in the written warning that was in the exhibit that was attached to the defense motion. The state did not bring up the audio of the warning as it was being given, but having listened to a number of these are often read in a monotone by the officers. And so what you hear is, you have the right to counsel and the right to have them with you during questioning. And the district court agreed and said, after Cerna, why is it so difficult for police officers to add in the additional language and make it clear? So the district court and the Court of Appeals saw this as a limitation on the right to counsel. Because it's all stated as one statement, there's no real break, there's no pause, there's no comma.
Well, but there is an and bringing two clauses together.
There is an and, but I think it would be asking a lot of defendants or suspects to understand that that and is such a break that when the only thing they hear is during questioning, that they have the right to counsel prior to questioning. And California versus Priceoff and many other cases have found that tying the right to counsel to a future point in time is prohibited. So I would say that, I mean, obviously the state feels otherwise, and this court may read it with an and, but I think it's asking a lot of someone under pressure, being held in a police station or wherever the custodial interrogation is taking place, to understand that that means he has the right to counsel prior to questioning, which is important under Miranda. I think the more difficult and the more important case before the court today is State versus Atencio, where the warning was extremely general. It read along the lines of, you have the right to an attorney, and if you can't afford one will be appointed for you. There was no further description of when the right begins. There was no telling him that he had the right to counsel ahead of time. And that is the case that is the more difficult question. If you look at cases around the country, both federal jurisdictions and states, that type of warning is analyzed differently depending on which court is looking at it. There are cases, and the state is correct, that there are cases that find that a general warning is sufficient. I believe that better reasoned cases find otherwise. And if you look at some of the cases that the state cites, first of all, some of them actually say more than just you have the right to counsel. They talk about you have the right to the presence of counsel, which I think does have more meaning, and that's why Miranda emphasized it. Or you have the right to consult with counsel, which also is more significant than you have the right to an attorney at the end. But then there are cases that find you have the right to an attorney is sufficient. In looking at those cases, I think it's important to look at their reasoning, because I think they have flawed logic. What they do is they look mostly to California versus Priceoff, where the United States Supreme Court announced in the beginning of their opinion that they took California versus Priceoff on purpose in order to make it clear that there is no rigid requirement as to the language of Miranda. And they felt that the California court there was being too rigid and expecting every warning to be exactly the same. And their point was, the warnings don't have to read identically. There is no verbatim advisement that we need to give, but they have to convey the requirements of Miranda. And then they specifically said that tying the right to counsel to a future point in time is not allowed. And so what these courts that find general warnings sufficient say is, well, California versus Priceoff says there is no rigid verbatim warning. And at the same time, they say tying it to some future point in time is prohibited. So we find that because this warning is not tied to a future point in time, and there is no rigid requirement, that a vague general warning is sufficient. The better reasoned cases find otherwise, and they rely on the specific holding of Miranda, which is that a suspect subject to custodial interrogation be advised that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. And the three main cases that the United States Supreme Court has considered since then have found each warning sufficient, but each warning in Duckworth versus Egan, California versus Prysock, and Florida versus Powell says you have the right to an attorney before questioning in one form or another. They don't all use the same language, and so it's correct that there is no verbatim warning that need be given, but those concepts must be conveyed. And CERNA, and it is dicta because CERNA really dealt purely with a temporal limitation, but CERNA has a heading: Miranda warnings must convey the right to the presence of counsel prior to questioning. And they say it is clear from both Miranda and subsequent decisions by the United States Supreme Court that there is a right to have and consult with counsel prior to questioning. And the fact that Miranda stresses presence means the word presence does have meaning. And if a suspect is told you have the right to the presence of counsel, that tells him he has the right to get an attorney right then and there, in so many words. Whereas you have the right to an attorney means nothing. It means I might have the right to an attorney when I go to court. I might have the right to an attorney after questioning is over. When do I have the right to an attorney? And in a state like New Mexico's, which I'm not asking this court to decide the state constitution, but I think some of the policy considerations do come into play. And, you know, we have many cases recognizing that New Mexico does have a large bilingual population. And I didn't include it in my briefing, but I think it's common knowledge that New Mexico also falls very low in all K through 12 educational rankings. So where we have an undereducated state and a large bilingual population, we should be reading Miranda to enforce what it requires, that a suspect be very carefully told that he has the right to the presence of counsel and that he has that right prior to the beginning of questioning. So I think these are all important considerations. I think that, you know, I cited cases in my brief where states have found that Miranda does require the right to, or the advisement of the right to counsel prior to questioning, or at least more specifically, the presence of counsel at a minimum. And that is as far as I have gotten on the Miranda portion of this argument. If the court doesn't have questions, I can quickly go to my cross petition. Yes, okay. I understand that in some cases, I mean, in some sense, this, on the cross petition, if this court were to find that the warning is not adequate, which Mr. Atencio believes it is not, and the Court of Appeals found it was not, then he would get a new trial without the admission of his statement. So in some sense, the argument is premature, but in case this court were to rule against him on that warning, he believes that the evidence is not sufficient for the amount of counts that he was convicted of. And the reason for that is that this case is different than Lente because the victim in this case was unable to pinpoint the time during which the alleged events occurred. And so unlike Lente, where there was a general period of time that the child was able to testify to, that was not the case here. The child couldn't remember what season it was. He didn't remember living in Kirtland. There was a lot he was unable to testify to. There was one instance that was testified to by his sister, but the requirements of Lente about the child's ability to testify to some of the more basic information that would be required just wasn't here. And then as far as using Mr. Atencio's statement to support the jury's convictions, the state charged this in set charging periods. Mr. Atencio's statement does not refer to any charging periods. The officers didn't question him as to any period of time. So where he said something like 20, 25 times, that might be 20, 25 times in a week. And so some of those times may not fall into a specific charging period. And there essentially is insufficient evidence to find as many counts as the jury found.
Can I?
Absolutely.
Not regarding your counter petition, the argument you made regarding Atencio. So you said presence, and I heard you say kind of two things: presence is sufficient, or presence. We need more than presence. We need before or during questioning. So, is it fair to say that you think the word presence would suffice for law enforcement to be saying before or during questioning with the word presence?
I think it's a bare minimum. I think that by saying you have the right to the presence of counsel, you've said more to the person being questioned than simply you have the right to counsel. But I think it's the bare minimum, and I think that New Mexico should require more. I think that telling a person specifically that they have the right to consult with an attorney prior to questioning is important, and it meaningfully conveys what Miranda requires.
You said right to consult, isn't that right to an attorney? Which right to consult is different from presence.
Well, the right to the presence of an attorney is what Miranda requires. Many of the cases use the word consult, which is maybe why I've gone back and forth. I think either one is fine. You have the right to the presence of an attorney prior to questioning, or to consult with an attorney prior to questioning. I believe.
But you keep saying prior to questioning, so that's my question. Are you hanging up on the word presence as long as the buzzword presence is used? Or do you need to add, law enforcement need to say prior to questioning? Or if they say, instead of the right to an attorney, you have the right to the presence of an attorney, period.
Ideally, I believe the warning should read, you have the right to the, obviously not in so many words, since Miranda says, and all the other cases say, not verbatim, but that the concept that needs to be conveyed is you have the right to the presence of counsel prior to questioning.
I get that, but I'm trying to pinpoint you down to the word presence.
So presence, I believe that if a warning simply stated, you have the right to the presence of an attorney, it is more likely than with the warning given in Mr. Atencio's case, that a suspect might understand that he has the right to the presence of counsel right then. So that's why I say that would be the absolute bare minimum warning, but I think that it should really go further. I think this court should require a more explicit warning. Not specific words, but a warning that more explicitly conveys the right to counsel prior to questioning, because that is what Miranda requires.
Well, how do you reconcile in Miranda that they were very satisfied with the FBI warning, which said right to consult?
So That, I have to say, that is something I have thought about a lot, and I don't really know how to explain it. I think that within the Miranda opinion, there are some inconsistencies, but in the end, what it comes down to is the holding, which is that a suspect must be advised he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to questioning. I also think it's telling that while the FBI warning at the time was much more vague, after Miranda came out, the FBI changed their warning and it became more explicit, and they now warn about the right to counsel prior to questioning. And that warning is the one that was mentioned by Justice Ginsburg in Florida versus Powell, where she said that warning is exemplary.
What if the warning here was you have a right to counsel before questioning?
The right to counsel before questioning?
It's not the presence. It's not consult. You have the generic statement, the right to counsel before questioning.
I think that would be sufficient. And again, I think it's because all of the United States Supreme Court cases say there does not need to be a verbatim warning. But when you tell
And
someone.
what makes the word presence magical?
I don't think, I think
in
presence can be conveyed with other words. And if you say you have
presence
the-
or a substitute for that. I'm struggling with why that is the cure as opposed to you have the right to counsel before questioning.
Well, I agree. I think that the right to counsel before questioning is sufficient.
But I think
because-
you're telling, in response to Judge Marla Summers' questions, you're saying that the word presence or counsel or consult are magical somehow. But then if I add on before questioning, they're not magical anymore.
Well, I don't think there are any magical words. I think that it's, as all of the cases say, there is no rigid requirement as to how the warning is conveyed. And if you tell someone that they have the right to counsel prior to questioning, that implies presence. I mean, I suppose they could make a phone call, so the counsel would not be present. But it
So
at least-
presence to you is important if you don't have before questioning. But if you have before questioning, presence is no longer important.
Well, what's important is whether presence is conveyed. Miranda does talk about presence. They emphasize presence. And so there are different ways that words can convey the right to that presence. So if you have the right to counsel prior to questioning, even if you don't use the word presence, that conveys the right to consult with counsel prior to questioning, which is, Miranda's concern was that questioning can quickly become coercive and overbearing to the suspect. So what's important to someone being questioned is the ability to talk to someone, an attorney, and consult about whether they should be answering questions, or maybe have the person there to help them answer the questions appropriately. So given what Miranda's concerns were, I think that's why they say the words themselves are not crucial. You don't have to have a rigid form like we do for the implied consent law. You just have to make sure that the concepts are conveyed. And that's what all of the United States Supreme Court cases have said, that there is no set language that an officer has to use in order to convey that the person has the right to speak with an attorney prior to questioning. So whether that's using the word presence, using the word consult with, there are definitely cases where the words used were consult with and the court found that sufficient. So I think it's not so much the word that matters or the words used, it's the concepts, and the suspect has to understand that they have the right to speak with a lawyer prior to being questioned. Did I answer the question? Okay.
Anything else? Anything else?
No.
All right, thank you
Thank
very
you.
much.
Thank you, Your Honor.
Okay, let's take a slightly different example. If I say you have the right to a sandwich, is there anything in that statement that would make you think that you have to wait for dinner time to have the sandwich? No. Let's take another
Maybe
part
I
of it.
would.
Pardon me?
I might. Because I want it now,
Well,
where it comes to food. But anyway,
I believe I'm saying that you can have it now. Let's take another part of the Miranda warning. You have the right to remain silent. Does that need to be modified too? I don't believe anybody's ever suggested that. But after all, it doesn't say when you have the right to remain silent. So if that doesn't need to be modified, what's the real difference between that and you have the right to a lawyer that supposedly does need to be modified? One theme that comes through the case law that's quite clear, I submit, is that adequate and best are not the same. In this area of the law, some courts might say, well, we can improve on that warning. We can make it better. And maybe they could. But that is not the standard for reversible error here. Supreme Court's Florida v. Powell case says that. A number of the Federal Court of Appeals cases say that. They say, well, we think it'd be better practice if you said such and such, but then they go on to approve the same warning that was used in Atencio. Presence and consult. Ran across a Supreme Court of Nevada case, State v. Stewart, 393 Pacific 3rd, 685, which says very simply, the right to an attorney is the right to consult with that attorney. So adding consult, I submit, doesn't do anything additional. Presence, I just have never seen a case, nor has the defense cited one, which draws a distinction between right to an attorney and the presence of an attorney. Again, I think it's fair to say that you have the right to an attorney, you have the right to an attorney present, not just on the phone. Chiramonte, defense contends that there's a temporal limitation there. I disagree. The word "and" means something additional. Your suspect was told you have the right to an attorney, and you can have them present during questioning. The warning did not say something like you have the right to an attorney, but only during questioning. That would be a limitation. Finally, as to the charging period in Atencio, it's true that the child here, as is often the case in cases like this, didn't have a very good memory. But the Court of Appeals correctly looked also not just to the defendant's statements in the interview, but to the testimony of the child's parents. And that's perfectly permissible. If you look at Lente, this court didn't just look at the child's testimony, it also looked at some testimony from the mother, because all of the evidence can be considered. Does the court have any other questions?
I do have a question.
Yes.
The fact that a warning that was given, I'm just generally speaking, can be interpreted by reasonable people, educated people in one way, and then educated, reasonable people interpreted in another way, same warning. What does that speak to as to whether it adequately conveys the right?
I'm not quite sure how to answer that question. A lot of people can
Because we've sat here today and given different readings, I think by reasonable, educated people, to the warning, particularly in Atencio, and now you're also saying Chiramonte.
Well, maybe I can point to, I don't remember the name of the case, but it was a Michigan Court of Appeals case that the defense relies on, and it was a 2-1 decision. There was also a divided decision on whether to take the case in the Supreme Court. And take a look at footnote 2 of the dissenting opinion, and the dissenting judge basically said, only lawyers can chop language to the point where Miranda warnings are confusing. Ordinary people don't find them difficult. And I think there's possibly some truth in that.
Thank you.
Thank you.
Thank you. Thank you, counsel, for your presentations today. And the case is deemed submitted to the court as of today, and we will get you a decision as soon as possible. Thank you.